Hello and welcome. In a landmark 297-page judgment that was delivered on the 29th of May 2026, Justice J.B. Prajwala and Justice R. Mahadevan issued directives that are being called landmark in the field of trafficking for the sake of sexual exploitation. This judgment, in fact, has come after 22 years. I'm joined by Sunitha Krishnan, who is a Padma Shri, who is also the co-founder of Prajwala, an anti-trafficking activist, and also Aparna Bhatt, Supreme Court lawyer, who has stood with Prajwala and with his public interest litigation for 22 years in order to get this judgment that is now being called as landmark. Sunita, when you filed the case in 2004, the circumstances would have been very different, raid and rescue. Things have changed. Why is this now a landmark judgment, historic judgment as it is being called?
Thank you so much, Uma. I think this is landmark because for the first time in independent India, 77 years later, victims of commercial sexual exploitation, victims of trafficking for commercial sexual exploitation have been recognized by the law as somebody who has the right to rehabilitation. They have a right as per Article 21 and 23 read together. This particular judgment also brings in the first ever victim protection plan, which is unique by itself because it's an institutional mechanism created and has the statutory powers of the law for to be implemented and complied by all the states, and which makes every stakeholder accountable to ensure that victim is the center of all interventions for her. So I would call this judgment as one of the best victim centric, trauma informed, right based judgment that has ever come in the favor of sex trafficked victims across the country. And for that alone, it is both landmark and historical.
Yes, indeed. Aparna, 22 years taking with such a case, which I believe, I understand, twice was in fact dismissed, and you again filed miscellaneous petitions and brought this case back, and to be able to get such a judgment, what has this journey been like for you? Staying with something that is so grave and something that has so many implications for thousands. We will go into the numbers so that our audience also understand what kind of numbers we're talking about when we say trafficking. But how has this 22 years been, this journey been, Aparna, for you?
You see, it actually cannot, it's like kind of surreal for us to see that it's actually been 22 years. It was like yesterday when we drafted. Every hearing, every day, every moment of it is kind of, it's part of our system. But and let me clarify, it was not dismissed. It was disposed of twice. Both times because we trusted the government. The first time when government made given undertaking, they filed an affidavit in which they said they plan to bring out a new law for dealing with human trafficking, and they also said they want to set up something called the Organized Crime Investigative Agency, which will exclusively look at human trafficking. So this is on affidavit, and Organized Crime Investigating Agency is not something they thought they just didn't conjure that up. They worked on it. There was a budget plan. There was a justification. There was a sanction from the finance ministry. It was a detailed process. And how do we know it? Because an affidavit was filed enclosing all those documents at that time. So we had no reason to disbelieve the government. Neither did the court have a reason to disbelieve. This is in 2015, December 2015. Nothing much happened as far as OCIA is concerned. But as far as the law is concerned, they set up a drafting committee. Sunitha was part of the committee, and there were many others. They first brought out a law which they were not happy. It was circulated. And then, in fact, after various, taking everyone's comments into account, the bill was actually introduced in the Lok Sabha. It passed in the Lok Sabha. This is in 2019. And then, so in 2017, when 2 years had passed, out 2015, nothing had happened, I moved the first application saying that they should comply. They didn't since they hadn't complied, the court issued notice to them. In 2019, when the Lok Sabha, the bill got passed in Lok Sabha, the matter came up in court. We were very confident that okay, now that the bill has passed Lok Sabha, it will definitely get passed in Rajya Sabha too. But for some reason, they did not table it in Rajya Sabha. Then the term expired. Then the bill lapsed, and then we waited for 3 years after the next government was sworn into power. Same political dispensation. They came into power. In fact, of course, not me. I'm an advocate in Supreme Court, but the activists in the ground level, like Sunitha and others, anti-trafficking activists, were also actively advocating with the government for this bill. And the 2022, when we filed the second application saying that nothing is being done, government's first response was, we have already drafted a bill and it is awaiting cabinet approval, and they attached the bill to their affidavit. But they said, as far as OCIA is concerned, they said now we have NIA. We've amended the NIA and added trafficking in the schedule of the NIA. So NIA will look into certain kinds of offenses of human trafficking. And that was their stand when they filed the reply. In 2024, when the matter got heard by Justice Prajwala and Justice Mahadevan, since some time had lapsed, the ASG said, okay, let me place a fresh affidavit on record, taking into account the current stand of the government. That is when we were shocked when they said that we don't need to amend the law, because our new criminal code, which came in 2024, all the three, the three acts which came in, BNS and BNHS and other things, they say it covers whatever was supposed to be done in the new law, so we don't need to do anything. As far as OCI is concerned, NIA is dealing with it, and they file many things like, we have sanctioned for 800 AHTUs, we've done this and that, we've complied with it. So that was the stand taken by the government in 2024. That is when the matter got argued all over again. In fact, in some sense, although it has been so late, we are happier with this judgment than the 2015. I'll tell you why. Because now we have something very concrete with us. At that time, we were reduced to negotiating with the government again, and which we are really exhausted negotiating with them, because the fact that human trafficking is a crime and is an organized crime is something that the government acknowledges. It's not as if it is not acknowledging, and the numbers are increasing is something that the government is conscious of. Why they are shying away to deal with it in a way it needs to be dealt with, I definitely am unable to understand.
Even
So
now,
in
I
that
mean, before
way,
we get into the details of the judgment, even now, beyond whatever else that it has done in terms of defining trafficking, sexual rehabilitation, and so on, victim rehabilitation, and so on, what the judgment is actually saying is that you must now get a comprehensive legislation bringing in all the
it's a
fragmented portions that
recommendation.
are there in the anti-trafficking law in different areas, isn't it? Whether it is
See, it's
BNS
a
or
yeah, it's a
Exactly.
recommendation. It's a recommendation. See, that's what the Supreme Court does. Even if you remember, 30 years back when Vishaka judgment came, that's exactly what happened. The court said, we acknowledge this, it's violation of fundamental rights. It's you same Article 21, Article 14, 19, and everything at that time. And they said, we would like the government to pass a law. In the meantime, we are going to make this. And they set out some guidelines. It's identical to that. The court has said that they recommended to the government to pass a law, but they said right now do it with these things, and they've given I think that the victim protection plan that the court has proposed runs into about 7 pages. That's a significant part of the
40
judgment.
pages.
Yeah, I mean, there's background, but actually, no finding, step by step what you need to do.
Yeah.
That's about 7-8 pages. So there's a huge. So that's what Supreme Court has
yeah.
done now.
Yeah. Sunitha, ever since this judgment came and everyone acknowledged this as historic and something that is landmark, there has been reporting that has caused little bit of a confusion about what really is the judgment saying with regard to what is being called as, in quotes, voluntary sex work. Explain to us what this judgment is actually saying about people who may be in so-called voluntary sex work. How is it different from what was happening earlier? Because earlier also everyone was being rescued, but no one's opinion was probably being asked. I would like you to explain why this is protecting, having that human rights that you mentioned, as a human rights uh, drive into this entire process.
So, Uma, first of all, I want to express my anguish and disappointment at some media groups and including online media who have, kind of cherry picked on the judgment and taken one small part of it and highlighted that as the main judgment. Let me be very clear. This judgment is for victims of trafficking, of commercial sexual exploitation. Period. This judgment is meant for that. It is not meant for adult sex workers, which is where the confusing narratives, some, I would say, some as vested interests are spreading. Now, what does this judgment talk about? The judgment very clearly talks about who is a victim of sex trafficking. And therefore, if this person is the victim of sex trafficking, who is not a victim of sex trafficking? So that distinction has come out in the judgment very, very clearly. So they have taken the Palermo Protocol, they have taken the BNS, they have taken the Immoral Traffic Act to define who is the victim of sex trafficking. At the same time, acknowledge that there are women who might opt for prostitution by choice. And in a particular rescue situation, this is also acknowledged in the judgment, that in a particular rescue situation, a police might actually remove or rescue all of them. And, the judge points out three kinds of people who could be, rescued at any given point of time in any rescue operation. One of them could be women who are actually trafficked. The other one could be women who are trafficked but have normalized the experience and now are doing it willingly. And the third group of people are people who are doing it voluntarily. So the judge, the judgment acknowledges this practical reality on the ground and provides a relief on this practical reality. So what is clearly given in the judgment is all of them have to be removed. Point one. After the removal, it is the magistrate who has to do a very clear threshold inquiry on what this person wants. Is she wanting support for care and protection? Does she want to go back to the same situation? Her voice has to be heard. And if only the magistrate is convinced, then the magistrate can take a decision. Suppose the magistrate is confused in terms of whether this, and because this whole process is being done with the assistance of a panel of social workers who will help the magistrate make that assessment. And suppose the magistrate is not very convinced of what the person is saying, or the person has said something and the social worker's report has come as something else, and the social worker feels that this particular person is saying under threat or duress or some kind of coercion to say, I'm doing this voluntarily and nobody has done, then the judge can actually ask for a deeper inquiry. So this is what has been, this has been a practical problem for every police officer. How do I make out, if you go inside a brothel, how do I make out, whether this is voluntary or not? And now with technology coming into the situation, Uma, the numbers that we started in 2004, official number on record, the government had given 3 million. Today into 2026, the 3 million is not 3 million. And one doesn't even know how many more millions, And with technology, the problem has gone much more underground. And there's a whole optics and narrative of consent that is created by the grooming exercises that traffickers do. So consent itself has become a very fluid word, especially when the word grooming comes into the picture. In such a context, this judgment becomes imperative in terms of, plays a very, very critical role, that the judge actually acknowledges that people on the ground, whether it is a magistrate, whether it is a police, will go through certain ambiguous situations, and how to deal with that ambiguous situation, that is clearly laid out in the victim protection plan. Who does
You
what,
spoke
how
about
does what.
that her voice must be heard. The one sentence that caught my attention was the right of a sex worker, even if there is no right to sex work per se. Does that limit itself to her voice being heard, or beyond that also there's an explanation of her now? When we say the right of the sex worker is something that needs to be protected, is that something we're talking about newly now in this directive that's come in this judgment?
You see, there was the law is always there, and the judges have not gone beneath or beyond the law. They've stuck to the law. What did Section 17 of the ITPA said? Section 17 is a section which authorizes even adult people, adult women largely, to be placed in a protective home in certain circumstances. This judgment has clarified it and divided it in this way. It says when at the time, it acknowledges that at the time of rescue, it is impossible for anyone to be determined whether this person is a voluntarily doing conduct, carrying out commercial sex, or if she is being forced. It's difficult to determine. So they say bring them all together, and there's some guidelines of how you bring them. And then once you bring them together, if it's clearly a child, there's no doubt. Then the children go to the child welfare committee. There is no doubt. If it's a case where it is you're in doubt whether it's a person is a child or an adult, like teenagers and adolescents and those such people, then assume that she is a child. So 18 years old, 19 years old, you can't make out that they're children. Then assume that they're children. If it's clearly an adult, in such cases, she has to be taken to a magistrate. The magistrate will have to do two things. First, has to ensure that she gets a lawyer, and that lawyer clearly should not be a lawyer representing any of these brothel owners or traffickers. It's very clear. And then after that, the girl has to voice an opinion, and she has to say whether she wants to continue in prostitution, or she would like to access services of the government for her rehabilitation. If she says, I want to continue in prostitution, the court will have to ask the social worker to give a report to actually investigate and check whether under what circumstances is she saying that I want to voluntarily continue, because the judge acknowledges the fact that even in cases where she actually says I want to go back to prostitution, she may have been influenced to such an extent that her own agency is compromised. The court is acknowledging that. And in cases where the girl's opinion that she wants to go back or not, and the social worker's opinion are at variance, then a deeper inquiry has to be done. It's only after that that she can be sent back. So it is not something that in the police station the police have the power to segregate and then let go, or because as things that's being canvassed is at the moment you raid a brothel and there are some adult women and they say that no, we don't want to go with you, we want to access our agency and then right, and then we want to be free because we are doing it voluntarily. The judgment doesn't say allow that. So these headlines coming in various newspapers are making people believe that this is what it is. That is not what the judgment said. That is a very clear misrepresentation of the judgment.
Sunitha, very often you speak from policy advocacy to the rescue raid, all of that. You actually physically participate and you have physical experience of all this over so many years. Uh, this judgment, obviously, now, like both of you have explained, um, gives some clarity to police also to operate, and for the law enforcement and the judiciary to know exactly what to do in these kind of cases without any kind of ambiguity about the definitions, which ultimately end up being ignored. So, what is the specific takeaway for a police, for social workers in this kind of scenario? What does this judgment give them? And I would also like you to talk about, you said the numbers now become that much more unclear because we have cyber trafficking, and where obviously numbers, you don't even know where to count and how to count. That is a big challenge. Is that also something that this judgment is actually addressing?
Yes, Uma, first of all the aspirations that all of us had, all the advisories and all the, all the stuff that we're trying to do with, say, sensitization of the judiciary or sensitization of police officers, today has become a law. So now it is binding. So now it's not like, the good intention of a person, or the, the niceness of a person to do it. So we always had in every state some good officers and many officers who are fence sitters, meaning because it was not binding on them to do things, in this manner. Now this law makes it binding, that this is the way it has to be done.
It's a
And one of the
constitutional right
things,
now. Hmm.
absolutely, Uma, for the last 8 years I've been sending letters after letters after letters to government of Telangana to notify the anti-human trafficking units in Telangana as police stations, and they have never given it even a little bit of weightage on what we are doing. And this has not just been my demand, but several others have said, because the current state of anti-human trafficking units is that they can only rescue and then the victims are handed over to law and local police, which means the same bandobast duty, same lack of priority, and so the cases of sex trafficking becomes like a routine number for them. It's just 10 people removed and that's about it. Now this judgment makes very clear that all anti-human trafficking units have to be declared as a police station, have to be notified as a police station, which means there will be better investigation, there will be better cases registration, and definitely because of that there will be better conviction rate. Now we are dealing with cyber enabled human trafficking, we are also dealing with traditional form of sex trafficking. Both of them are going hand in hand. And in this scenario, when the situation has become so grave and grime for the country and for the entire world, such clarity of thoughts in terms of who will do what, how it has to be done, and also accountability. The one of the most beautiful part of this judgment, Uma, as I said earlier, three things that takes a lot of importance for me as an activist. One, making rehabilitation as a right of a victim, which means the
Not a
entire
charity anymore,
WCD.
not a disciplinary action anymore.
Absolutely. And which makes also WCD more accountable, because they have to give rehabilitation in the right way. And the second thing that the judgment brings out again, which defines rehabilitation for me, is a definition of dignity that has been stated in the judgment. And the way the judgment says is dignity for a victim of trafficking, of commercial sexual exploitation, is not to be commodified, number one, to be recognized with respect, and three, provided all material well-being, you know for a meaningful life. So that is in toto what rehabilitation should mean. So rehabilitation is not removing one person from one place and keeping them in another place. It has to move towards giving them a meaningful life, with all the material well-being, which also ensures that they have the right kind of identity. And the third part, which is very important, which was not there ever from the beginning to now, is to ask what the victim wants. you know what is her aspiration, what is her needs, what does she wants to do. Now that has become part of the law, then the magistrate is mandated to ask her, her thoughts and her desires, her needs, and what she wants to do. So at every step, whether it is at the threshold inquiry stage or the deeper inquiry, or when care and protection is put for a longer time, every step, she is consulted. And at every step, she has the right to go back and say, I want this or I don't want this. Also, for the first time, we had section 19 in the Immoral Traffic Act for a very long time. This is for any woman who is in prostitution, and the word prostitution is predominantly used in the judgment from beginning to end. Okay, so any woman in prostitution can voluntarily come to the magistrate and say, I need care and protection, can you provide me a space? So in this judgment, for the first time, that you know statute has been described, and the procedure for section 19 has been laid down. So there is space for victims of sex trafficking, and there is also space for adult women in prostitution to opt for exit, both of which has been provided from this judgment. So what more can one ask for in terms of both the segments? And I say that, and I will not include Aparna in that, I'm a hardcore abolitionist, and the judgment also very clearly defines who's an abolitionist, and describes what is the different ideology. I'm an abolitionist. I know, publicly acknowledged abolitionist. For me, if the law says exit mechanism should also be provided for those who want to leave, maybe they have to made a choice in some constrained circumstances, but if they want to leave, they should know how to leave, and law provides a way for it now in a very clearly systematic manner. And that is why all these misinformation and all these digressing tactic is bothering me, because the core of the judgment is getting lost, and the core of the judgment is upholding the rights of victims of sex trafficking and ensuring that there is an enabling environment for them to gain back their dignity.
Thank you, Aparna and Sunitha, for breaking it down so clearly, lucidly for us so that we can understand what the implications of a judgment like this is. But one last thing, uh, while you're happy about the many things that have been clearly spelled out in this judgment, uh, you just mentioned that the Telangana government was either due to ignorance or inertia or lack of infrastructure, not following up on recommendations that you and other activists were making. So when the Supreme Court says something like this, that bring about a comprehensive legislation that will take care of all these aspects, is there never a deadline, timeline that the central government will need to follow to make this into a comprehensive law?
No,
So,
it's a
Aparna,
recommendation. It's a recommendation so that government can do it according the way they want to do. But in the meanwhile, the Supreme Court judgment is there. The directions are there. So that's the law. Till such time a law comes into force. And as far as the AHTUs is concerned, the court has directed that all AHTUs should be declared as as police stations now. So what we wanted as far as AHTUs is concerned has happened. So that is the law now. That now they'll have to implement it. So they've been given 3 months to comply with everything and file a compliance report in the court. So the court has not kept it, disposed it. They've called them to come and comply. So they are actually following through. You see, what happens in many PILs is the judgment comes after there is no implementation, and people like us keep going back and asking them to comply, and then we point out this has happened, that's happened. Unlike those instances, in this case, the court has kept it pending and asked the Supreme Court, that they've listed again in September 2026 and have asked all the state governments and the union to file a compliance report. They've shifted the onus on them to come and inform the court what steps they have taken to comply with this judgment. Yeah.
and
It's actually.
on our part also, Uma, we are not people who are here just to file a fancy PIL and get a good judgment, sitting for 22 years. We are committed to the cause, and therefore we also plan to do whatever is required from our end to support the government of not just Union of India but
All
all the
government.
states, all the state governments, to see how we can assist them in implementing these directions, because end of the day we all have to join together. If trafficking is an organized crime, we also have to be organized to fight it. And we from Prajwala, and Aparna is Prajwala to that extent, is that we are committed to stand by all the stakeholders. And interestingly, this PIL in the beginning was never adversarial. In the first
Through
15
the
years
time,
of
yeah.
the year, through the
Even
time,
now, even now.
even now, it's not adversarial. We want to join hands, and we want to see our expertise and whatever we have learned from the ground. Prajwala comes with a huge experience of removing 32,000 and more women and girls out of prostitution and commercial sexual exploitation. So whatever we have learned from what we have done is something that we would like to offer to all the state governments to take this forward in whatever way we can support them, and we are committed to that. So we want this to be implemented as much as they want it to be implemented.
We do need partners like you. It's a
Yes.
massive task, and without partnerships, I don't think we can get anywhere. And 22 years, actually, you see, in the last 1.5 years, I don't know the number of conversations Sunitha has had with me and I've had with her about the fact that this is taking such a long time. But somehow, after this has come, we have forgotten that 22 years that had lapsed.
Yeah. It's
Yeah,
as if,
so we
yeah,
are so
yeah,
we
yeah.
are we are grateful to both the judges.
Yes.
And we are
And
grateful that both of you persisted in this battle and got this kind of a judgment. Policy, advocacy, work on the ground, all of it got together and showing the country the way to take in dealing with these kind of uh, illegal activities that are both a shame to society and also something that we need to focus our attention on. Thank you so much, Aparna and Sunitha Krishnan, for joining us on Decoder.